Ed, we are ready.
Okay. Good evening, everybody, and welcome. Congratulations to Commissioner Gonzalez, Commissioner Hammelberg, and Vice Mayor Kennedy on your election/re-election. The first thing I want to do is to commend to you the orientation manual that Roseanne sent out. Thank you. Because we're really going to be working mostly off of that. I have some other stuff that I want to get to. This is really just intended to be an orientation. It's not, we're not going to go in depth into a lot of areas, but I just want to give you the basics that I think will be helpful for you going forward with this commission. And obviously, if anybody has any questions after we're done, please feel free to contact me or Valerie with any specific issues that you have. I'm going to give you our numbers, even at the risk of making them public. We're going to give you our phone numbers for you to contact us if you need us. And as you'll hear from part of this presentation, we actually encourage you to do that. So let's start with the fact that you're now an elected official in the state of Florida. You have certain responsibilities and duties that you have to fulfill. You are very much like a member of a board of directors of a corporation, because that's exactly what this is. It's a corporation, and your job is to adopt policy. The policy that you want to have in the village of Biscayne Park, and then the manager is going to implement that policy on your behalf. You have what's known in what most places in the state of Florida have a commission manager form of government, where the commission sets the policy, the manager implements the policy. The manager is going to administer all of the village services that are provided, whether it's recreation, whether it's the police, whether it's public works, or any of the other departments within the city. One of the most important things we can talk about tonight is what's contained in the charter with respect to your duties and responsibilities. Section 402 of the charter specifically prohibits a commissioner from being directly involved in the administrative affairs of the village. You are not able to hire or fire any village employee but for the manager and me or our firm. You are, however, can and are encouraged to make recommendations for improvements in the village to the manager. You cannot, however, direct or order the manager to take any specific action. For example, last week we had an issue with respect to some flooding that I know was a big deal. You cannot pick up the phone and tell the manager to send a vac truck down to a certain address in order to do that. You can certainly point out to him the fact that there's an issue down there, but it's up to him or her to decide what action is going to be taken. You don't get to make those decisions. And you can only deal with other village employees through the manager, so that you should not be talking to the director of public works or the police chief or anyone like that. If you have any issues, you're supposed to be directing them specifically to the village manager. And let me just stop for a second and say, I'm excited about the fact that you guys are going to be hiring tonight Mario Diaz. He and I have had several conversations since he was originally appointed last week. I think he's going to do a superb job for you folks if you'll give him the opportunity to be the manager of the village and let him implement your policy as you dictate. What I'd point out to you is any violation of those provisions that I just talked about is grounds for removal from office by an action brought by the Miami-Dade State Attorney. We certainly don't want to have any of that happen. If you have any questions with respect to that before you get into any trouble, please contact us and let us direct you accordingly. So we talked a little bit about the village manager. Let me talk a little bit about us. You know that our firm is Neighbors, Giblin, and Nickerson. The firm has been around for 35 years. I've been with the firm since 2007. Valerie's been with the firm now for just about a year, but she has prior experience in other municipalities. And we're here to serve as your legal counsel. The rules of professional conduct of the Florida Bar specifically provide that an employer employed by an organization represents the organization. In our case, it's the village. And specifically, it's you folks as the village commission. So at any point in time, 3 of you can act as the client by a majority vote among yourselves. So we're a counsel to the village, to the commission. We are not your counsel, and we're not the public's counsel. We've had several instances where people have asked us for theoretical, in my opinion, legal opinions, and we're just not going to provide those to folks because it's not our responsibility to do that. We will certainly answer any questions that the commission has, but we are not here to provide legal advice to your residents. We talked a little bit about policy formation. And what I would suggest to you is that board decisions or commission decisions are generally made up of several factors. Number one is operational factors. Do we have the structure and the people necessary to implement this particular decision or policy? Financial factors, clearly, do we have the money to be able to do it? Number 3 is public policy factors. Is this in the village's best interest? By doing this, are we neglecting something else that's more important? So you're going to have to be setting priorities. And lastly are legal factors. I would submit to you that the first 2 of those are is information that's generally provided to you by the village manager. Your colleagues and your constituents would help you make decisions with respect to that third one regarding public policy. And of course, we're here to provide you any legal advice that you need in deciding whether to implement a policy or how to implement a policy. So in addition to making policy, you're going to be called upon to make legislative decisions. And those are done by the commission by a vote. And they're either by ordinance, which is part of the code of ordinances that you have that deal with a whole bunch of things that can and cannot happen. According to state law, there have to be 2 readings for those ordinances to become effective. I don't think we have any on tonight, do we? We don't have any on tonight. And then the other thing would be resolutions, which generally deal with administrative matters, such as approving contracts, budget amendments, or expressing public opinions, such as the Village Commission did with respect to the flight paths and opposing the FAA's decisions to fly over the village. Those are things that are generally done by resolution. One other thing that will come up from time to time, and we just had it happen a week ago, which is a quasi-judicial proceeding. And that's basically where you actually sit as a judge and obtain evidence through a public meeting, through testimony or documentary evidence. And then you take that evidence and you apply it to the law, which in our case is the code of ordinances of the village, and to come up with a determination, just as we did last week with respect to that variance request. And I'm pretty sure that all of you were there to see that. One of the biggest laws that you are going to be faced with making sure you don't violate is the Sunshine Law. Now, the Sunshine Law has been around for quite a while, and basically what it is that it prohibits 2 or more members of the same body such as this village commission, from discussing any matter which may foreseeably come before the entire commission. Whether it's the terms of an ordinance, whether it's hiring the manager, whether it's hiring the attorney, any item of business that might come before the village commission cannot be discussed between any two of you unless it's done in a public meeting. And that public meeting, all meetings have to be open to the public. Reasonable notice of the meeting has to be given, and minutes of that meeting have to be taken. There is, I don't know, other than the ethics law, I don't know that there's another provision that's more important than the Sunshine Law. Now, it doesn't prohibit you folks from meeting socially, from going to parties together, to discussing the weather, to talking about your children or grandchildren. But you need to be very, very careful that you're not talking about any business that is foreseeably to come before this commission. But I'd offer one warning to you, that people are always watching. And now that you are in a position of authority, there are people out there who may not want to see you succeed. And if they see two or more of you engaged in conversation, somebody may take that the wrong way. And please understand that anybody can file a complaint. They can file a complaint with the Miami-Dade Commission on Ethics, with the Florida Commission on Ethics, or with the state attorney's office if they think there's a violation of the Sunshine Law. So, and it's not meant to scare you. It's just meant to make sure that you understand what you're prohibited from doing. And plus, you can't do it indirectly by, for example, Mac calling up Roseanne and saying, "Hey, Roseanne, will you tell Judy, that I'm going to vote in favor of this in the next meeting?" You can't use intermediaries. You can't do anything indirectly, which you're prohibited from doing directly. The next provision that I think is very important for you folks to understand is the Public Records Law. Any and all material made or received by the village, including you as a commissioner, in connection with the official business of the village, which is used to perpetuate, communicate, or formalize knowledge, is a public record. Every email that you send to me, to the manager, to the clerk, to anybody dealing with the business of the village is a public record. And it doesn't matter on what device you use to communicate that information. Text messages are public records. Emails are public records. Letters are public records. Even if you receive it on your private computer, your private tablet, or your private phone. So, and you personally, if you are conducting that type of business on one of your personal devices, you are responsible for maintaining that in case we get a public records request. For example, someone could say, "I want all of Commissioner Gonzalez's text messages from tonight through December 31st. And please recall that the person who's making that request does not have to give a reason for the request. Anybody can request a public record at any time. So what we generally recommend is that you not use your personal devices for village business. You have email addresses through the village. If you are communicating by that email address, then the village will have record of that. It will maintain the record of that so that if a public record is requested, we have the ability to go and search for that and provide that. Otherwise, you are going to get a call from the clerk or from the manager or from me that says, "Do you have any other records on your personal devices which comply with this request. As a result of that, I strongly encourage that you not use your emails unless absolutely necessary. Please, and I'm telling you this from my perspective, and I know that I've talked to the incoming manager, and he totally agrees that we would much rather do business with you over the telephone, especially if it's of a sensitive nature, than having it made a public record by way of email or some other type of communication. Please don't text me. I don't want to maintain those records. And I'm pretty sure that Mario doesn't either. So, if you can, please communicate by telephone. It just makes it easier for everybody when a public records request is met. Now, that's not intended to mean that we are a secret society and we're only going to communicate by telephone. But there are certain things that just don't need to be put in writing, and I'm sure that you folks, understand exactly what I'm trying to say. The next thing that's most important for you is voting and conflicts of interest. According to Florida law, you must vote on every item requiring a vote unless you have a conflict of interest or the appearance of a conflict of interest. The conflict of interest in my mind is very simple. If any measure that comes before you would inure to your private gain or loss, your employer's private gain or loss, or a relative or business associate's private gain or loss, you have a conflict of interest. You cannot vote on the item. You must declare the fact that you have a conflict of interest and why. For example, this vote would benefit my brother. And then you have 15 days within which to file with the clerk a memorandum, and we have a form for that, so you don't have to worry about it, that specifically discloses in writing what your conflict of interest is. That obviously becomes a public record, and anybody can access it at any time. Let me give you an example of what not to do. When I was a Broward County attorney, one of my commissioners had an instance where her husband was working for one of the municipalities within the county, and the county was giving out grants to the municipalities for parks, recreation, open space, and the commissioner asked me if she should abstain from voting because her husband worked for the town. And I told her that if he was obtaining any benefit as a result of her vote, that she should declare a conflict of interest, abstain from voting, and file the required memorandum. If, however, he's not obtaining a benefit as a result of her vote, then she has to vote on the item. She decided, and I put that in writing, she decided to go ahead and vote on the item, even though those votes were totally non-controversial on the county commission. They always passed unanimously if it was from within that commissioner's assigned district. The Broward County State Attorney's Office believed that she had violated the law because it subsequently came out that her husband apparently received a bonus for every time one of those grants was approved by the county commission. She went through years, and I mean years, of litigation with the Broward County State Attorney's Office, and ultimately ended up pleading to a lesser offense, but it cost her pension in the Florida retirement system because she couldn't collect it while she was under investigation, actually had been charged with a crime. So if at any point in time you think that your vote is going to benefit one of those people, yourself, your employer, a relative, or a business associate, please talk to us before you cast your vote, so that we can talk about it and we can give you the advice necessary to avoid that type of a situation. And the next to last thing I want to talk about is ethics. I think the ethics code is pretty simple. You can't take anything from anybody if it's intended to influence your action, whether it's a vote or some other action. You can't solicit anything from anybody upon the understanding that your vote or your action may be influenced by the gift. You cannot conduct business with the village. For example, if you owned a vac truck, you could not contract with the village to come in and vacuum out water from a flood, because you're a member of the board of directors of this organization. And lastly, with respect to ethics, you can't misuse your position. You may not corruptly use or attempt to use your office to secure a special benefit for yourself or others. And the statute's very clear. What it says is or others, which means anybody, not a relative, not a business associate, not your employer, anybody. If you're corruptly using your office to secure a special benefit for someone else, then you're violating the law. You may get a complaint filed against you. You do not want to go to Tallahassee and visit with the folks at the Florida Commission on Ethics. I've represented people in front of them, and they've taken a pretty hard line when it comes to that stuff. The last thing I want to touch base on has to do with dealing with us. Now, some people say there's no such thing as a stupid question. I completely disagree. There are several questions that should not be asked at our public meetings unless we've cleared it between us in advance. The first one is this: is it legal? Any lawyer worth his salt is going to tell you that it's legal, because the issue never would have gotten that far in the first place, as long as you've discussed it ahead of time. The second one is, can we be sued? Well, of course we can. Anybody with $400 can sue you, can sue your colleagues, can sue the village anytime they want to. And that question is not going to help you decide whether to take that action that you want to take or not. And then the last one is, will we be sued? Frankly, you might as well ask me what the lottery numbers are. I can't answer that question. But I would suggest to you this: if you and your colleagues believe that you're doing the right thing, after previous communications with us about that particular issue, it really doesn't matter if you're going to be sued or not. Everybody has the right to sue you. That should not be a determining factor in you making your decisions. Now, when we interviewed for this job, we told you I've been practicing law for over 40 years. And, I really prefer, and I passed the bar a long time ago. I passed the bar, but I did pass it. And we really prefer to have the legal questions answered before we get to the public meeting. Now, I understand that in the heat of discussion sometime, issues arise, where we weren't able to try and talk about it ahead of time. And the reason we want to talk about it ahead of time is so that we can gather all of the facts, research all of the law, and come up with the best possible answer for you. And it's very hard to do that all of the time just from shooting from the hip. I don't like to shoot from the hip. And I don't have the answer, and Valerie doesn't have the answer to every possible legal question that you folks could pose to us. So there are going to be times where we're going to have to say, time out, commissioners. We need time to research that issue and come back to you at the next meeting, or we'll provide you with a memorandum or something to that effect. So with that, I'm more than happy to answer any general questions that you have. But again, I'm very impressed with the manual that Roseanne had sent out for the orientation. I think there's a lot of other good information in there for you. If there are specific issues, again, that you have questions of, we're more than happy to try and answer them now, or subsequently. Go.
If no one else is going to jump in here, I have a couple of things I'd like to ask you. It's
right.
Mac. I'm sorry you can't tell when I'm talking with my mask on.
I can hear you.
So, okay, very good. Can you hear me through my mask okay?
Yes.
Okay, good. So heading back to, resolution, ordinance, and those things, I understand, having done this for a couple of months, I understand the ordinance part. I got that down. And, but I have a question about when a resolution is required. And because I think we've had some instances where it's in the middle of a meeting, someone says, well, that's going to require a resolution and we don't have one. And so when is a resolution required? And then the second part of the same question is, there are other times when we just sort of agree on something. When is it appropriate for the commission to just sort of say, hey, are we all in agreement on that? Yeah, cool, we'll do that. So when is it as casual as we all agree, let's move on? And when does it require being a resolution?
Yeah. If it's something that's procedural, something that's administrative to the commission itself, we can dispose of those things by motion. But if it's something that, like I said, approving a contract, you want to see that contract, we need a resolution approving the terms of that contract. Budget amendments, any other issues, a recommendation to the, a recommendation to the manager, I think you can do by consensus. He's going to be sitting there. He's smart enough to see that the majority of his commissioners want something to happen, and he's going to be nodding his head, and the formal resolution is probably not necessary in that case. It's not necessary in that case. I'll just say it. Okay. But it's for the routine types of things, not a big deal. But if it's something that I think you want a resolution for the FAA thing, right? You want that to be out there. Right. You want to publish that so that the FAA and your neighboring cities and towns and villages, can see that as well. And it can be distributed to whomever you want. But a lot of these things I think we can do informally.
So I think what I just heard you say is if it's something that is something it's internal and it's just kind of like a family conversation, we can come to an agreement on consensus. If it reaches into money, bigger items, or the village is speaking with one voice to somebody outside the village, then it needs to be formalized a bit more.
I think that's okay. Fair. I'm not precluding other things, and we really kind of have to do that sometimes on a case-by-case basis. But if it's something that needs formalization, then we're going to probably require it be by resolution.
Okay, so let's say a hypothetical, and I'll give one that's just kind of absurd and it's not going to happen tonight, but I'll pick something off the agenda. The Halloween decorating awards. And we all agree on this and we hash it out and we agree on it. And then Valerie says, you know what, you better put that in a resolution. I mean, I know the I hope the decorating awards don't require a resolution, but that wasn't done by you before the meeting. Can we agree on it, direct the manager to move forward on this item while you work on a resolution and bring it back to us? Or do we have to actually vote on the resolution and have it signed by the mayor before we can move forward with something?
Now, if there's a consensus, then we're just going to formalize it, for the record. Okay. But you've already in effect voted. I mean, you will have taken a vote, or you'll come to a consensus. And all we're going to do is to formalize that decision for the record.
Got it.
And
Okay.
we're not going to hold it up, to have to wait until the next meeting in order to approve it.
To move forward. Okay. Next question is something I've wondered a lot here. Remember, I've been a commissioner for 10 months, but only 1 month of that do we have an actual manager in place. So I've been working with interim managers, and so it's been a little more, cumbersome and tricky the past couple of months. But now we're moving forward. It's a new day. In a meeting, when and why is a motion required? Because we seem to trip over that an awful lot. So we're having a conversation. When do we have to have a motion, and when do we not have to have a motion and a vote? And when do we not?
Whenever you're going to take action. For the Halloween thing, the Christmas thing, I'm sure what you're going to do later tonight, and we're in a public meeting, so I can say this, is that you're probably going to make a motion that we do the holiday decorations, if you will, the same way that we did the Halloween decorations, or some words to that effect. We need a motion to do that because we're taking action, and we're requiring other people to take action.
The staff has to do things. There are steps that need to be done. Okay.
There are certain things, like adding stuff to the agenda. We generally don't have to have a motion for that. If there's a consensus to do that, then we just need to move on. Okay.
Okay. Because I've always heard someone make a motion to accept the changes to the agenda and to accept the agenda and move forward.
Yeah, and that's what's generally done. But
okay.
And I probably would request that we continue to do it for stuff like that. But there's it's hard, Mac, to think about it right now off the top of my head. But there's some things, that we just need a consensus on. Like can we take a 5-minute break? We don't need to take a vote on that.
Okay.
The routine,
so it's the really casual things. We can just be consensus stuff.
Yeah.
Okay. Very good. Last question. You touched on something. You said something, and then I wrote down a question, and then you answered it. But I have to ask it as well, because it sounds so odd to me when you're talking about public record. And I've had people request public records of me, and it's not that big of a deal for me because it's a big deal for staff. They're the ones. I handed my phone to Roseanne and said, "There you go. Have fun. Enjoy that." And she said, "Oh, you text a lot." And I said, "Yeah, I do. There you go. Have at it." So, but you said it's better to talk on the phone than to put things in an email. And it does sound like I'm not saying that you're suggesting that we skirt things, but it sort of sounds like you're purposely not making things on a record so you don't have to go through the trouble of providing those to somebody when they request them. That's how it sounds.
Well, good.
So when does something really need to be? Because I also don't want to call you and Valerie and Mario 5 times a day. I'd prefer to shoot off an email, say, "Hey, when you have a second, can you tell me what I need to do about this, or give me a piece of advice on this," and not bug you, and then you can address it when you have time.
But frankly, it's the same. We have to stop what we're currently doing, read your email, draft an email in response, whereas we could do a 30-second telephone call and accomplish the same thing.
If I can get somebody on the phone, that's the other tricky thing. Everybody's busy, and this is not my full-time 9-to-5 job, so I squeeze in things when I can. Then a lot of it's on the weekends, or you've gotten emails from me at 5 a.m, at 10 o'clock at night.
Oh yeah,
because that's when I have time to do stuff.
I do.
And I told you the first time we met, and I do not expect a response at 5 a.m. or 10 at night. That's just when I have an opportunity to do it.
I get it, and that's the way you do business, and I'm certainly not going to dissuade you from doing that. But the fact of the matter is, not everybody deals with it that way. A lot of commissioners prefer to just pick up the phone and say, "Hey, listen, I got a couple of issues. It takes us 30 seconds or a minute, to figure out what it is that we need to do, and we're done." Whereas, we've got to stop, we got to read it, we got to think about it, we got to respond, and sometimes it just takes a lot longer.
Okay, then how about if I shoot an email to you or Valerie or Mario and say, when you have time today, I have 3 questions that'll take 15 minutes. Let me know when you can do it. I'm taking lunch at 12. Can we do it
Perfect.
then?
That's perfect.
Okay, let's do that. Okay, very good. Thanks. That's all my questions.
Yeah, and Mac, I'm not trying to dissuade you from doing. I understand how you operate. I mean, obviously, I've seen it for the past several months, and I'm not trying to stop you from doing that. I'm just suggesting to the new commissioners, that we do not have no objection to answering your phone calls if you have a specific question about a village piece of business. So
I understand. Okay, thank you.
So whatever,
Thank you.
Art and Judy, whatever works for you guys will work for us, I promise.
Wonderful.
Not hearing you.
You're not hearing?
Muted.
I'm hearing you because I'm sitting next to you, but I'm not hearing you through the headpiece.
You're muted, Art.
Or maybe it is.
It's taking a little while to unmute.
Use the cursor.
There you go.
All right. Okay, so hi Ed and Valerie. Thank you guys for coming tonight. So obviously, being new to this, I have a lot of questions, and I have. Do I hear a lot of feedback? Yeah. Okay.
Better now.
All right, good. So I have a lot of concerns and some feedback from the times that I would sit in this audience and I would get super frustrated. And one of those things was that, people would get up here during public comment and they would share their opinions, and some of them had, some significant and legitimate questions. And it would seem that, they would completely be ignored. Once the public comment piece was done, nobody replied to them. Nobody took the time to answer any of their questions. So I went back and I started looking at some of the old meetings back in from 2016 and whatnot. And they actually took the time to answer not all of the questions, and some of them aren't questions. Some are just some criticisms, and some are just, moaning and whatever they do. But some of them are legitimate questions, and some of them, and the mayor gave the commission an opportunity to, if they would like, to answer some of those questions. And I've been told since then, right or wrong, that we are not allowed to answer questions from the community when they are posed. Is that actually the case?
No.
No, it is not.
No, unless there's a pending lawsuit and someone wants to come and talk about that, it's certainly not a legal issue for us.
Okay.
If it's a policy issue, that's something I think that you and your fellow commissioners need to talk about on how you want to address that going forward.
Right, but I mean, sometimes they have, specific questions in regards to, a budget issue or a finance issue.
Right.
I think that, we can answer, but yet, for whatever reason, we just decided not just to completely ignore their questions. So I think that that's something that we need to work on. So I appreciate that we do have an opportunity to answer when residents come up and ask specific questions.
Yeah, I think, and I'm going to defer to the manager on this, but I think a lot of those questions probably should be answered by him. If they're budget issues, if they're service issues, there's a pothole, in my neighborhood or something like that. But there's no legal prohibition against you folks responding to your constituents.
Okay, good. I'm glad to hear that. Another question, and I think that this might come up in the regular commission meeting, so I don't want to skip ahead, but is that we've been talking a lot about individual commissioners and spending a lot of time with attorneys on phone calls and whatnot. And so I'm not quite sure what the rules and regulations are in regards. And obviously you've been doing this a long time, so you have some experience as to how that procedure typically takes place. So my question is, what has been your experience as to, you know, the particular commissioners making phone calls to you on a regular basis or a lot of basis and spending a lot of time with you on the phone? Is that something that typically is directed through the manager, or is that normal that that commissioners spend a lot of time with you on the phone?
Yeah, I think what you're going to find is that once you folks develop a relationship with the manager, that would normally be your first call.
Okay.
And I would think that a lot of the time that he would have the answer to your question, because it's lots of times not particularly legal in nature. But if he thinks that it is, he would either direct you to us, or he would call us and get the answer and report back to you. That we deal mostly with the manager, but again, we're not discouraging you folks from talking to us. The way the relationship is set up, I think is that you're not charged anything additional if commissioners pick up the phone and talk to us.
Right. No, I understand that. I just want to understand what is the typical model of communication with a village or a city with its manager.
It's usually commissioner to manager to attorney, and if necessary, then attorney back to commissioner.
Okay.
But again, there are no hard and fast rules when it comes to that, and we're trying to obviously be of service to all of you folks. So whatever works for you will work for us.
Okay. All right. Thank you. That's all I have.
Yes, sir.
Thank you very much.
Judy, you okay?
You're muted, Judy.
All right, I'm fine. I'm just taking it all in and getting the information.
Yeah. I know that you folks are going to have other questions coming up. And I know what I just said, but please, either email us or call us if you have something specific, and we'd be more than happy to respond to you. But again, we just wanted to give you a thumbnail sketch, and hopefully this maybe generate even more questions for you down the road. But I think that once you folks have been to these meetings, sitting through these meetings for quite a while, you know what the process is, and you'll be fine, especially once Mr. Diaz gets on board and you develop that relationship with him.
I have one more quick question. Oh, I'm sorry. Go ahead.
Commissioners and Mr. Attorney, can you hear me?
Yep.
One thing I just want to make sure to communicate is, with my experience in communications for the past over 15 years, and especially in government, I wanted to make sure that it was at least said here tonight. Ed mentioned the Sunshine Law. That also applies to communication versus any social media outlets as well. And so if you're discussing anything with regards to village business, you do not want to be discussing those items with your fellow commissioners, especially on social media. That could be viewed as a violation. City of Miami Beach has been sued for it, and former Mayor Levine was not found favorable in that lawsuit. I believe Pensacola or city around Pensacola is currently in an active lawsuit for various social media. So please be very careful when you're on there as to who you're communicating with and what you're speaking on, so that you're not violating sunshine or public records within social media.
Right. For example, I think what he's trying, if one of you says something about village business, the rest of you should not be commenting on that, or it might be considered a violation. You can
Okay.
say you can say whatever you want to yourself, just not responding to a fellow commissioner's post.
So let me make sure we're clear on that, because it's actually on the agenda tonight, but since you're discussing it now, let's just clarify it. So any of us can go onto social media and talk village business, but another commissioner cannot respond back to them.
That's right.
That's very clear. Thank you for that very short explanation. A quick procedural question, or Ed, I haven't really talked to you very much. I've been trying not to be a big bug to you, but I have called you, and then once or maybe twice, Valerie, I called you. Did I call you twice? I can't remember. I know one time we had an actual conversation. It was before the last commission meeting, and my conversations tend to take place right before a commission meeting if there are things on the agenda that I just need, hey, tell me about this. Like before the variance, I had a kind of a lengthy conversation with Ed about that, because I wanted to make sure I was fulfilling my obligation properly, and I wanted, I had some legal questions because it's a quasi-judicial matter. Now, had Mario been in place, I'm sure I would have called him first and said, hey, Mario, help, and he may have said, go talk to Ed. But my question is, when do we call you, Ed, and when do we call Valerie? I called Valerie because you didn't answer your phone. I had a quick question, so I called her on something. But I don't want to bug the wrong person. So who would you prefer we call, or I call?
Whoever.
Maybe you want to push me off on Valerie?
No, whoever.
Okay.
Which one?
There's the answer. Well, that's what happened that night. It was Valerie who was the one. She didn't have me saved in her phone yet, so she answered.
One of the other things, and Mario and I haven't talked about this yet, but in every other jurisdiction that I've been in, is prior to a commission meeting, the manager and the attorney generally has an agenda briefing so that we can go through the agenda and try and answer any questions you have in advance of the meeting, so that we don't spend a whole lot of time going over stuff that we could have explained to you in advance. Now, I understand that you folks, have a need to explain it to your constituents from time to time. That's not what I'm talking about. I'm talking about if there are any legal questions or management types of questions that we can get you the answer for in advance. That's the way we do it. In fact, we spent 5.5 hours today briefing commissioners in another jurisdiction on the agenda coming up on Thursday. So we would much prefer to do that. So that we can get all those questions answered in advance of the meeting, which will help, hopefully, make for smoother meetings and still impart the information that you folks want to impart to the residents of the village. But we'll talk about that once he gets on board.
Ed, if you don't have much more to add,
I'm done.
We need to close to prepare for the next meeting.
Okay.
All right.
Is this a motion or a consensus, Ed?
This is a workshop.
It was a joke, is what it was. It was a joke.
This is a workshop. And don't make me come over there.
You want to?
Okay, see you guys in a few minutes.
All right.